This Nonprofit Basics episode is the third of a three-part series on election year activities of public charities and private foundations. Part 1 addressed the prohibition on intervention in candidate campaigns for elected office. Part 2 focused on legislative lobbying activities for public charities. This third part addresses private foundation approaches to policy advocacy that are allowed by the Internal Revenue Code. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. As I mentioned in parts 1 and 2 of this series, professionals working in the nonprofit space know that Internal Revenue Code Section 501c3 has some key language that limits their ability to engage in electioneering and lobbying activities. Candidate campaign activity is prohibited altogether, excepting only nonpartisan get-out-the-vote activities. Legislative lobbying is covered under the specific language of 501c3 too. The relevant part of that says an organization is described as a charitable organization only if, among other things, no substantial part of the activities of the organization is carrying on propaganda or otherwise attempting to influence legislation. Remember, while all private foundations and publicly supported charitable organizations are 501c3 organizations, only those that pass tests for public support can avoid these additional restrictions that apply to private foundations. Episode 5 of the EO Radio Show addresses the rules that determine whether a 501c3 is a public charity or a private foundation, so check out that episode for explanations of the different categories of charities. In further limitation to the lobbying activities that apply under 501c3, in 1969, Congress added penalty taxes to the Internal Revenue Code for private foundations because of concerns that private foundations had become increasingly active in political and legislative activities. And these new rules, well, new in 1969, were intended to provide more effective limits than were set by the general language of 501c3. These limitations are in a separate section of the code, which is 4945. And that section imposes a stiff penalty tax on private foundations that fund legislative lobbying, participate in political campaigns, or fund certain voter registration activities. These restrictions on private foundations are regulated by an expensive excise tax. Under the current rules, an initial tax of 20% of the amount of each prohibited electioneering or lobbying spend is imposed on the private foundation. And an initial tax of 5% of each taxable expenditure is also imposed on the private foundation managers who knowingly agreed to making the taxable expenditure. So, for example, if a private foundation makes a grant for lobbying activities of $300,000, the private foundation tax is 20% of that for a $60,000 penalty. A second-tier tax can also be imposed on both the private foundation and its managers if the expenditure isn't corrected within the specific periods defined in the statute. Note that the foundation manager's liability for this penalty is limited to $10,000 in the case of the initial taxable expenditure, or $20,000 if the foundation manager refuses to agree to the correction of the inappropriate spend. So, using the example of a $300,000 lobbying grant, the tax on the manager would be capped at $10,000. In order to correct an impermissible lobbying act, the private foundation has to recover the disallowed grant funds if at all possible. Like most other private foundation rule violations, the IRS has discretionary authority to abate the initial tax on a private foundation if the foundation can show that its violation of these rules was due to reasonable cause, not willful neglect, and the foundation corrects the taxable expenditure. So now that we've covered the penalty and decided we really don't want our private foundation to go there, let's talk about what the terms mean. Under the rules that apply to a private foundation, the term taxable expenditure includes any amount paid or incurred by the private foundation to carry on propaganda or otherwise attempt to influence legislation, either through an attempt to affect public opinion, which is grassroots lobbying, or through communication with any member or employee of a legislative body or other government officials or employees who may participate in the formulation of legislation. That's direct lobbying. So understanding these rules requires some work on the defined terms. Here, they are legislation, administrative actions, direct lobbying, grassroots lobbying, and the meaning of the phrases call to action and advocacy communications, since all of these are relevant to determining whether the foundation's expenditures are classified as taxable lobbying expenditures. So let's start with the term legislation. What does that include? That means any action by Congress, any state legislature, any local council or similar legislative body, or by the public in a referendum, ballot initiative, constitutional amendment, or similar legislation, and with respect to the introduction, enactment, defeat, or repeal of these acts, bills, resolutions, or similar action items. Legislation does not include administrative actions. It does include both foreign and domestic laws. The next defined term to focus on is the meaning of the phrase administrative action. This means action by an executive, judicial, or administrative body, such as a school board, housing authority, sewer and water district, zoning board, or other similar federal, state, or local special purpose body that isn't comprised of elected officials. Next, it's important to distinguish between direct and grassroots lobbying. Direct lobbying means a communication directed to a legislator that refers to specific legislation and reflects a view on that legislation. An important note here is that in the case of a ballot initiative, direct lobbying includes communications with the public, since in a ballot initiative, the people are the legislators who vote for the ballot, for or against the ballot initiative. A communication is defined as grassroots lobbying if it meets 3 criteria. It refers to specific legislation, reflects a view on the legislation, and encourages the recipient of the communication to contact their legislator with a message encouraging the legislator to vote for or against the legislation. This defined term is important because a communication that is initially within the nonpartisan exception, which I'll cover in a few minutes, can later be recharacterized as lobbying if that communication is used in a grassroots lobbying communication. A footnote here, some states do require reporting by organizations that are engaged in administrative lobbying, but those rules don't affect the organization's tax-exempt status. Take a look at the show notes for links to some information about state administrative lobbying limitations. Private foundations that are very careful about not engaging in legislative lobbying under these federal rules sometimes get caught up in these state reporting requirements for state administrative lobbying. So a word to the wise there. Just because the foundation has navigated the federal lobbying rules successfully doesn't mean there aren't traps for the unwary at the state or local level. When spending private foundation funds for policy advocacy activities, be sure to also check the state and local rules to avoid a misstep here. So let's talk about exceptions to these rules that are often important to private foundation advocacy activities. There are a number of exceptions that allow private foundations to make grants or even spend directly on nonpartisan analysis, study, and research, technical advice or assistance for a governmental body, appearances before or communications to a legislative body in what is referred to as self-defense of the private foundation, and examinations and discussions of broad social, economic, and similar problems. So let's explore these exceptions for private foundations in some more detail. First, the meaning of nonpartisan analysis, study, and research is covered in detail in the IRS regulations. Amounts spent on nonpartisan analysis, study, or research are not taxable expenditures, regardless of whether the results are made available to the general public or to governmental bodies, officials, or employees. Analysis, study, and research qualifies as nonpartisan if it is an independent and objective exposition of a particular subject matter, including any activity that is educational. The analysis, study, or research may advocate a particular position or viewpoint so long as there is a sufficiently full and fair exposition of the pertinent facts to enable the public or an individual to form an independent opinion or conclusion. And that's a quote directly out of the rules. But keep in mind that the mere presentation of unsupported opinion doesn't qualify as nonpartisan analysis, study, or research. A private foundation may distribute the results of its work in this area in any way it likes, but it may cross the line and no longer be considered nonpartisan if the dissemination is limited to or directed toward people who are interested solely in one side of a particular issue. So whether the full and fair exposition standard is met is generally determined on a presentation by presentation basis, except for when there's a series of publications or broadcasts that otherwise meet the nonpartisan requirement. The series can be considered as a whole under the facts and circumstances of the situation. So while a series of videos that present the results, where each program individually might not be regarded as nonpartisan, the series as a whole could be considered a balanced presentation. But if the programming is disseminated in a manner prejudicial to one side of a controversy, it may be considered under all the facts and circumstances to be a partisan communication. Next up is the relatively narrow exception for spending to provide technical advice or assistance to a governmental body or a governmental committee. This exception applies only to advice or assistance that is provided in response to a written request from the body, committee, or subdivision of a legislative body or committee. The request must come from the requesting governmental body rather than from an individual member, so typically from the chair of the committee, and the response to the request has to be available to every member of the committee. The technical advice or assistance under this exception may be given as a result of specific knowledge or skill in a given area that the foundation has. The presentation of technical advice or assistance doesn't have to fit within the nonpartisan analysis, study, or research rules, and the private foundation can offer its opinion or recommendations. But that communication will ordinarily qualify as technical advice or assistance only if the opinions or recommendations from the private foundation are specifically requested by the committee or are directly related to the materials requested. Examples in the regs include a situation where a congressional committee, which is studying the feasibility of some particular legislation in a technical area, requests in writing that a private foundation describe its views on that technical issue. If the foundation's views remain directly related to the subject of the committee's request, the amount the foundation spends for the presentation and for travel and other costs in presenting it will not be treated as impermissible lobbying expenditures. A few notes about the self-defense exception. It's also somewhat narrow, but it does come up occasionally. Amounts spent by a private foundation to appear before or communicate with a legislative body concerning a possible action by that body that might affect the foundation's existence, its powers and duties, its tax-exempt status, or deductibility of contributions to that foundation generally are not taxable expenditures. For example, under this self-defense exception, a private foundation may lobby Congress to consider modification of current private foundation excise tax provisions, or to oppose a bill that, if enacted, would affect the foundation's tax-exempt status. The final category of exceptions applies to examinations and discussions of broad social, economic, and similar problems, and this category is often relevant to private foundation spending. The exception applies to spending for examinations and discussions of broad social, economic, and similar problems, which are neither direct nor grassroots lobbying, even if the problems are of the type that the government would be expected to deal. This exception applies to public discussion and communications with members of a legislative body or governmental employees if the general subject of the communication is also the subject of legislation before the legislative body, as long as the discussion from the private foundation doesn't address itself to the merits of the specific legislative proposal, and as long as the discussion doesn't directly encourage the recipients to take action with respect to the legislation. The regs provide the following example. A private foundation may present discussions of problems such as environmental pollution or population growth that are considered by Congress and various state legislators, provided that the discussions are not directly addressed to the specific legislation being considered. and also provided that the discussions do not directly encourage the recipients of the communication to contact a legislator or a governmental official or an employee of a governmental official or legislator who may participate in the formulation of the legislation. Grant-making private foundations that fund policy activities often make grants to public charities that do engage in legislative lobbying. So moving on from the exceptions, let's talk a little bit about grant-making private foundations that fund policy activities. These grant-making foundations often make grants to public charities that engage in legislative lobbying, and there are special rules that guide the private foundation in this regard. The purpose of the private foundation grant and how it's documented determines whether the grant triggers an excise tax under these rules. A general support grant to a public charity does not constitute a taxable expenditure if it's not earmarked for lobbying, even if the public charity engages in lobbying activities. Similarly, a specific project grant is not a taxable expenditure by the foundation, even if some portion of the grant is ultimately used for lobbying, but only if it meets two requirements. First, the grant is not earmarked to be used in lobbying activities. And second, the sum of all the grants made by the private foundation for the same project in the taxable year of the grant cannot exceed the amount budgeted by the grantee in that year for non-lobbying project activities. So let's examine that second criteria. It's kind of the tricky part of this reg. For example, if a grantee proposes a specific project for funding by a private foundation, and that proposal from the charity has a total budget of $100,000, of which the lobbying expenses are budgeted at $20,000 and non-lobbying expenses are $80,000, as long as the private foundation's grant isn't more than $80,000 towards that specific project, and the grant agreement doesn't earmark the grant funds for the lobbying activities, any grant amount by that private foundation up to $80,000 will be permitted under these rules. In fact, if 5 unrelated private foundations each grant $20,000 for that project and cover the entire $100,000 budget, none of those private foundation grantors is treated as making a lobbying expenditure so long as their respective grant agreements don't earmark their grant for lobbying expenses. This is so even though all of the foundation grantors in this example effectively do fund the lobbying activities. On the other hand, using this same budget example, if any one private foundation made a grant for the specific project that exceeds the $80,000 of non-lobbying expenses, that foundation would be treated as making a lobbying grant because the amount in excess of the non-lobbying portion must have been intended to fund lobbying activities. So in thinking about these rules, a grantor private foundation is allowed to rely on budget documents or other evidence such as a signed statement by an officer of the public charity grantee, showing that the proposed budget of the specific project meets these criteria, unless the foundation otherwise doubts or has reason to doubt the reliability of the documentation provided by the public charity. So these rules make it imperative that the private foundation carefully review proposals and that the private foundation is clear in its diligence and documentation surrounding grants to public charities that lobby. Listeners who would like to hear more on the topic of election year activities for nonprofits can find links in the show notes to our recent webinars on the topic, as well as links to IRS materials and other resources to help navigate these waters. That's all for this episode. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martell. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.